my colleagues who may want to make additional comments, I want to draw the court's attention that we do have a bail application. I don't know whether the court wants me to do this after that, this application. We do have a bail application, criminal application number 0213 of 2026, which has been allocated to you, my lord, and we will be seeking for dates at the end of this, noting that our clients have been in custody, A1 and the A2 have been in custody for a whopping 558 days as of today.
So I don't know whether all of us. That's all. For A3, that's all for A1 and 2. For A3.
Council Simmons. The Lord, we join issue with the submissions of Senior Councilman Karua. Also, politely remind this court that every has pending bail application which is 0698 of 2095. Pray that court be pleased here this application at its eliminated audience.
Before I give directions or guidance, media from the defense, if there is full disclosure tomorrow, not later than 5.
How will it be communicated?
No, I have made a report that it must be communicated. It's not negotiable.
That's okay. Since he has confirmed before the court, we will put disobedience in as well. So we leave it there.
Yes, if moving to give further directions, if you are fully get full disclosure tomorrow, later. So, I want to give directions, you will be ready for them.
We have indicated we have a pending bail application which has been allocated to the court.
Does it have a date?
No, it
Does
does.
it stop me to give directions to this one?
No.
That's what let us
I was waiting for you to finish so that I raise that.
No, I am this one.
Okay.
Tomorrow, I have ordered Treason to get full disclosure tomorrow. So, next.
We are waiting for you, my lord.
So I'm asking you, before I get a date now for here.
My Lord, you need to confirm one that the disclosures have been made, and upon the disclosures being made,
I said I have made the audit, it's a must.
then
I'm not
the
going
defense,
for this celebration.
then
Tomorrow, I have made the audit is in people.
she said the next step is scheduling of the case, a date for that to happen. In which case, after the disclosures, we will have assessed the time we need for preparation. In the absence of disclosures, we will not be able to know. Yeah.
My Lord, I don't think we need a day for scheduling. We will have just this matter to have a hearing date. Because for us, as prosecution, we shall produce our first witness then.
Just a minute. So, our praying for?
My Lord, as a prosecution, we are praying for a hearing date in this matter.
Confirm that we make full disclosure and then
We are going to make full disclosure by tomorrow. And our prayer is to have a hearing date. And on that date, my Lord, we shall be bringing our PW 1. Our prosecution witness number 1.
It's all very well for the prosecution to state that. Is the prosecution therefore assuming? Is the prosecution assuming that the accused persons have no right to prepare their defense?
what I'm asking
No,
you. For him, he said that he confirms that he was followed by the
Yeah.
and he's applying for the hearing date. So,
Okay, then I'll let my colleague, Mpanga, respond to that.
Not under the law under which we are proceeding.
which one?
That's the TIK. The number of housekeeping rules that is under which is. Yes. For example, one of which, there is a procedure to be followed.
Which section is that? I want to.
My colleagues. We're going to go to 67. 67, my Lord, provides for the mandatory section 67, subsection 1.
Kindly read it, Papa.
Notwithstanding section 66, we are covered by 66. If there is person pleads not guilty or a plea of not guilty is entered in accordance with section 63, the court shall, subject to the provisions of section 67, proceed to choose assessors and try the case.
So under the procedures that now choosing the assessors.
My Lord, under 67, notwithstanding section 66, when I
We're not going to keep with what we are supposed to do.
yes, that's what I have captured one
Choosing
thing.
the
Yes.
assessors.
Notwithstanding section 66, when you
So that is assessors is under which section?
I read 66. But I'll come to it as under section 66. Yes. So 67, notwithstanding section 66. When an accused person is legally represented, if an accused person who is legally represented who is not guilty, the court shall, as soon as it is convenient, hold a preliminary hearing in open court. Preliminary hearing in open court in the presence of the accused and his or her advocate, and of the advocate for the prosecution, to consider such matters as will promote a fair and expeditious trial. That is 67(1). So, my lord, that is general. 67(2). At the conclusion of a preliminary hearing held under this section, the court shall prepare a memorandum of the matters agreed, and the memorandum shall be read over and explain to the accused person the memorandum of the matters agreed. And the memorandum shall be read over and explain to the accused in a language that he or she understands, signed by the accused and his or her advocate, and by the advocate of the prosecution, and then filed. So that memorandum has been filed at A1 up to A3, and for their advocate, and by the very stability of who takes the view that is not necessary. Then the prosecution must sign it.
I thought he's saying that it's not necessary.
Because he was asking for a trial, so he takes the view. My lord, my lord, under section 68, at the commencement of the trial, and where the provision of section 67 have been, after the preliminary hearing has been conducted, each assessor shall take an oath of impartiality. At the commencement of the trial, and where the provisions of section 67 are applicable, after the preliminary hearing has been concluded, each assessor shall take an oath of impartiality to advise the court to the best of his or her knowledge, skill, and ability on the issues pending before the court. And my lord, we wish to, in light of that section 68, we also point out section 69. The accused person or his advocate and the prosecutor may, before an assessor is sworn, challenge the assessor for any cause. On the following grounds. A, my lord, presume no actual partiality. Personal cause such as infancy, old age, deafness, blindness, or infirmity, his or her character, being that he or she has been convicted of an offense which in the opinion of the judge renders him or her unfit to serve as an assessor, his or her inability adequately understand the language of the court, and when the challenge is disputed, the issue shall be tried by a judge, and the person challenged will be examined on both. So, my Lord, the point we are making is that after the preliminary hearing, where the memorandum has been signed, the state as the accused person have the right to test the assessors, confirm that they will execute their mandate. So, my Lord, that would require that the state and the accused counsel perhaps get the full anticipate of the persons proposed to be assessors in the matter, which we shall then test if the need arises after we have done the matter. My Lord, we take the view that it is necessary to have the preliminary hearing, given the nature of the disclosure, and the ability to make disclosure available. Yes, it's more. Best interest of the accused persons in the preliminary hearing will be served if we have managed to go through the disclosure with them.
Before I check. I don't believe
Lord, we are looking at 29.
That's Mpanga, the vote for section 66 again.
Is my Lord there?
66.
Yes, my Lord. 66, my lord. If the accused person pleads not guilty or a plea of not guilty is entered in accordance with section 63, the court shall, subject the provisions of section 67, proceed to choose assessors to try the case.
And which was now the assessors will take the details and what by the time you come you have their particulars if you want any background check, and we choose the assessors so that you go with the details.
So should we then give us the particulars?
That's what I'm saying. We think the registrar lined up about how many? 4? 5. 5 more. We shall choose out of 5 we can't have all of them. The registrars lined up 5. We can choose from 5.
And we assume that the registrar has their particulars.
So that's what I am going to check. The register lined up 5. In this matter, we can choose 3 assessors. Who is Besigye? Who is Mr. Mpanga? Mr. Okero Richard. Yasin Rafix. Pat Ward. One Mpanga. On the one in the state. That is the list of files that I'm saying we shall.
My lord, we are saying that we examine this, and on the time of choosing, then we shall challenge if there is anything.
I have given you the names of the assessors, they are 5.
Yes,
by
ma'am.
one.
Yes, ma'am.
Their names, their details, correct? So let us agree on the 5 matters.
My lord, it would appear that we can't choose now.
Why?
That's the law.
Why?
That's the law.
What did it say?
My lord, it is subject to section 67. It is subject to section
Read the 66.
If the accused person pleads not guilty,
Yes.
or a plea of guilty is not entered in accordance with section 63,
Yes.
the court shall, subject to the provisions of section 67, proceed to choose assessors.
Read 67.
Notwithstanding section 66, if an accused person is legally represented by, if an accused person who is legally represented pleads not guilty, the court shall, as soon as it's convenient, hold a preliminary hearing in open court in the presence of the accused and his or her advocate, and of the advocate of the prosecution to consider such matters as will promote fair and expeditious trial. At the conclusion of the preliminary hearing,
Now you are going to what?
67,
I want 66 is telling us
66 makes itself subject.
yes.
66 subordinates of section 67. So 67, the order is that we first conduct the hearing, then we sign a memorandum. After that, then we go to the choosing of the assessors.
I think after that you go to the swearing assessor.
Exactly. And my lord, they can only swear after we have.
The choosing is different from swear. I thought we would choose, but then later on we can take it.
The minority has a participation. 66 is subject to 67, which dictates that we must first have the committed on the 29th of May 2025.
And I will now proceed to make the following remarks and findings. That this is a case where the accused persons were committed in the lower court on 29th May last year. From the court report still, the matter was then filed in the criminal division on 27th June last year. And the file was allocated to me on 2nd July. However, this honorable court proceeded to fix this matter for hearing on 1st September 2025. I am aware and alive of Article 28 of the 1995 Constitution, which provides for the right of the fair hearing. Also aware that under Article 28(3)(c) provides that every person who is charged with a criminal offense shall be given adequate time and facilities for preparations of his or her defense. From the court record, the two persons took plea on 30th December last year. Since then, this court has been handling several applications. The one for witness protection, being one of them, has just been withdrawn today. Since this court has already made an order for full disclosure by tomorrow, 29th May, it is my considered view that for the interest of justice and for the time this case has taken, and avoid unnecessary delays, this case should be considered and the time that should have been remand. Therefore, this court will go ahead to give the following directions. 1. Preliminary hearing under Section 67 DIA and choosing of the assessors under Section 66 DIA is fixed for 1st June at 11. 1st June, we shall have that preliminary hearing, as Council Mpanga said.
It's a public holiday.
1st June.
Not here, but in Kenya, but I'm just wondering whether you would give us.
It is a preliminary hearing that has come here. Now, Council Karua.
It's okay. I'll wait for your orders and comments.
So we shall come here for preliminary hearing on 1st June at 11. Then Another thing.
One of the things we want the court to know is that the information on assessors is insufficient.
What is this?
We need, if it is one has a degree where they studied, we need a short
Just
bio.
wait, just wait.
Yeah.
What is missing?
If you look at that,
Let us start with one is what is hard.
they are all the same.
What is missing?
It is indicated like in this first one, it's indicated there's a degree in accounting and finance.
My question is what is missing that they can provide?
The university she went to, you know, the way
Under
one
which law
gives,
requires the assessor to have a university degree?
but how are we as people to be, it's not, I am not saying that the qualification, there is a law requirement. It is the information given.
This is what
If
I'm
you
saying.
say
I
you are
wanted
O-level,
them to see the information.
if you say you are O-level, we expect you to say, and I went to this school. Then a background check can be done. We expect to know where they come from.
My question is, maybe the guy worked on the assessor's details which the law provides. So can give
How
that
can
the
they
law,
put it?
so that we see what does the law say and what is missing.
I understand my colleague, he said, under section 69, 9 of the TIA.
Read it.
We are this person or his or her advocate, and the prosecutor may, we are 69 section 1. Yes, read it. We are this person or his or her advocate, and the prosecutor may, before an assessor is sworn, yes, challenge the assessor for any cause on any of the following grounds. Is presumed for actual paternity, yes, personal cause such as infancy, old age, deafness, blindness, or infirmity, yes, his character, in that he or she has been convicted of an offense, yes, which in the opinion of the judge renders him or her unfit to serve as an assessor, his or her inability adequately to understand the language of the court, yes. And then, my Lord, what my colleague is saying, yes, those are the,
So when you come here for hearing, if you have a ground under that, you shall over.
what my colleague appears to say, my Lord.
I can complete that. That in order to do a background check, to be able to challenge, to know whether we have a challenge
This is
on
what
any of the
Mpanga has
assessors.
read that look at it when you come on that day, you have any dispute.
My Lord, what my colleague is saying, that for counsel to be able to attend to those matters,
And I
Even
am
for
saying
them.
they have given this to the registrar. Can we capture what you want that is missing that they will have?
my Lord, what my colleague is saying,
Particularly
that if we say that we have a degree in law, you are asking us to go to all the universities. Yet if they say I have a degree in law from Karua University, you can actually go there and confirm. If they say that I am, for example,
so that is, you have a so, what you are saying, but they are providing everything. So that's what you are saying on these qualifications, they should provide that area.
yes, ideally, my Lord, I think it's something akin to what I would call perhaps a paid application. But if I say this buyer,
That's okay, let us go together back to this. Kind of get your qualifications and provide the registrar. Okay. That is important.
qualifications, it should be a good thing also to get a copy of their national ID to confirm actually that they are Uganda.
So, you know the good thing. So we are saying group of their qualifications on the national ID.
Some of them allege that they have work experience. It's a good thing to know where they have been working. And naturally, because they propose to be residents here, it would be a good thing to have a letter of confirming their conduct. What people really
they don't want to disclose their residence.
Yes, I know. That's
No, for us, data of business, qualifications, national ID, and experience.
And good conduct from Interpol.
I don't think something else.
Because you mentioned and we here, yes, I want to hear the over. Yes, I will listen and go back to the law. Yes.
My Lord, a letter from an LC wouldn't state that Mpanga State.
Where is that requirement under which law?
My Lord, you have to put there
Under which law?
because I cannot confirm that. I don't want to test it.
No, I'm asking under which law they are arrested.
My Lord,
Okay, I'm telling you, you will wait to do as I
what I'm
said.
stating, that because it allows for a mini trial, we don't want Mr. to be now ask Mr. Tucker to confirm that he has approved his residence.
Yes, yes.
So we request a full disclosure of the antecedents. The other thing, my Lord, is that it came from the accused that the disclosure that was given to us, my Lord, looks like this. The accused persons have not had a chance to perform. We have indicated, that's why we asked for that time, that the best interest of justice will be served if they have gone through the disclosure.
Now, I think let us separate this. On the first thing. We still have the years.
Yes, 67.
Yes. We shall do that preliminary hearing. What is there? You wait on memorandum, and if there are any facts, they are great. So after that, you will get time. It's not time for.
I love the estimate. Just for the memorandum, you are agreeing on so many things. You can't agree on things that you haven't comprehended.
Let us handle it on Monday.
Before you raised my Lord, I had asked for a hearing date for the bail application that is before you.
Let me first hear the hearing.
Just allow me a minute.
I am looking at it. Come to my
it-
chambers. Is the prosecution to discuss that.
But may I say in open court because it is necessary
I am
that
saying
you have been able to
that
give
what is
them,
not yet fixed.
yes, but you've been able to give the prosecution dates for their applications for appearances of fairness.
I am saying is that you don't need the matter is fixed. I mean, fine.
It's been allocated.
I have no first.
I'm sorry. If you look at section 67,
Let us meet you.
Never surrender.